Deliani Chinchilla. Oh my god. Deliani Chinchilla. Alright, let's put this on mute. Oh my goodness.
Kenneth, how's it going?
Good morning. Can you hear me?
Yeah, I can hear you. Can you hear me?
Yes, ma'am. Whew.
How's it going?
Just woke up. Tired. Oh.
Yeah.
Oh. How was your weekend?
It was good. How was yours?
It was nice. I'm going to Rome, Italy for 12 days.
Oh, when's that?
I leave on Wednesday. So, yeah, I leave Wednesday the 13th in 2 days. I show up in Rome on Thursday. My flight returns on the 25th Christmas, or leaves on the 25th of Christmas, and I show up on the 26th.
Okay.
And I already sent the email to pretrial services and all that. Oh. Whew.
Okay, so you'll be gone 12, 13 to 12, 25. Okay.
26 is when I return.
Okay. So after today, I will not see you until January 8th.
Oh, really?
Yeah, because if we can't do the session next week while you're out of the country. And then the following Monday is Christmas, so we're closed. And then the following Monday after that is New Year's Day, which we're also closed.
Oh, okay.
So we'll plan for the 8th.
Alrighty. Excuse me. Oh, whew.
Cool. Okay. Well, I'm jealous you're going to Rome.
Yeah, I finally got paid and I had enough money. I checked how much the tickets cost and how much hotel costs. Well, I got them.
Nice.
And yeah. Oh my goodness.
That will be a good time. You have plans for when you're out there? What you're gonna do or anything?
Go to the Vatican. Be a good person.
Yeah.
Oh.
Awesome. Well, I have a couple of videos for us to watch, and then we will call it a day.
Alrighty. Oh.
It seems straightforward when you first read it. The Sixth Amendment of the United States Constitution's Assistance of Counsel Clause provides, in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. As a basic tenet of our adversarial legal system, the Sixth Amendment's right to counsel provision tries to negate any imbalance of power between the legally knowledgeable prosecution and a defendant who is not as well versed in criminal law. A defense attorney can recalibrate any imbalance by advising the defendant of his or her rights and explaining what to expect at different stages of the criminal process, as well as investigating facts and presenting a legal defense. In one of the most high-profile U.S. Supreme Court cases in the early 20th century, Powell v. Alabama, the court outlined the important role the right to counsel plays in providing a defendant a fair trial. In that case, 9 African-American men, dubbed the Scottsboro Boys, were accused of raping 2 white women, and during their criminal prosecution, they were represented by counsel when arraigned, but no defense attorneys consulted with them or assisted the defendants beyond that. Defense counsel failed to even make a closing statement. The court found that the defendants' constitutional rights were violated based on the 14th Amendment's Due Process Clause. In the court's opinion, Justice George Sutherland wrote that the right to counsel is so fundamental and important that the right to a fair trial is meaningless without assistance of counsel. In the landmark 1963 decision, Gideon versus Wainwright, the court ruled that federal and state courts must provide counsel for those indigent defendants who cannot afford to hire their own. The court reasoned that the guarantee of counsel is so fundamental to a fair trial that it must be applied to the states through the 14th Amendment's Due Process Clause. And a person denied the right to counsel, even if it's merely a function of inability to pay, violates this right. A criminal defendant has the right to assistance from a lawyer at almost every important phase of the criminal process, from arrest and initial investigation all the way through an appeal after conviction. The right to counsel has been applied in so many critical stages of the criminal process, due in part to historical reasons. The Constitution's framers sought to establish a more involved role for counsel than what was prevalent in 18th century England. At that time, English defense lawyers merely advised clients in matters of law and didn't play an active role in the prosecution. Also, criminal prosecutions are more complex than ever. Early in the history of the American criminal justice system, evidence against the accused was accumulated at the trial itself. Pre-trial proceedings were inconsequential. Now, the bulk of the evidence against the defendant is gathered before a trial starts, so the results of pre-trial proceedings can potentially settle the accused fate, reducing the trial itself to a mere formality. In this environment, delaying the right to counsel until trial could render the right to counsel almost useless. However, the right to counsel only attaches when there is an initiation of adversarial proceedings. There is no constitutional right to counsel merely because someone is being investigated. An arrest is the commencement of an adversarial proceeding, and thus the right to counsel attaches during an arrest and at post-arrest hearings. In Rothjury versus Gillespie County, Texas police executed a warrantless arrest of suspected felon Walter Rothjury for illegal possession of a firearm. While at the county jail, Rothjury requested counsel but was not provided with it. Rothjury once again insisted upon a right to appointed counsel in front of a magistrate judge who read the charges against him. Again, he did not receive it. The court held that the government violated his Sixth Amendment right when it ignored his requests for an attorney. Know that a person does not need to be in custody or feel coerced to trigger the right to counsel. If he or she has been indicted, and if government officials are trying to obtain information against the person, then the right to counsel has attached, and the person must be provided an attorney upon request. Police cannot deliberately elicit incriminating information from an accused after the right has attached in the absence of counsel unless the defendant waives counsel or initiates the discussion about the case. A person can waive his right to counsel by effecting a voluntary and proper waiver, which means that the waiver was made knowingly, voluntarily, and intelligently. A waiver may be held to fail to be knowing or intelligent if the defendant was unaware of the nature of the charges and possible penalties if convicted prior to the waiver. A defendant whose Sixth Amendment right has been violated does have recourse. Courts are required to suppress statements
Can you
and
pause that and go
testimonial
back?
information that were products of the violation.
Go back
Yeah,
for
we're-
5 minutes.
Intelligent if the
Here?
Yes.
Okay.
defendant was unaware of the nature of the charges and possible penalties if convicted prior to the waiver.
So
A
right
defendant
there.
whose Sixth Amendment right has
we
been
pause?
violated
So does that mean that they're not allowed to question you unless they tell you the nature of the charges and the possible outcome first for the waiver to be valid?
I'm not sure.
Oh, okay.
It gets a little sticky with like the waivers and things like that, but they're good to know about.
Okay.
I would definitely write that down and ask your attorney though.
Alrighty. Thank you.
does have recourse. Courts are required to suppress statements and testimonial information that were products of the violation, which means that confessions obtained while denying counsel must be excluded. In Messiah v. U.S., the defendant, who was indicted on drug charges, retained a lawyer, pled not guilty, and was released on bail. While out on bail, Messiah made several incriminating statements in his co-defendant's car without his lawyer present after police had installed a recording device in the car. The court reversed Messiah's conviction and held that the government could not use the defendant's own incriminating words in the case against him because the right to counsel applies in all critical stages of a prosecution or any stage where a counsel's absence can adversely impact the accused's rights to a fair trial. This was even assuming the listening device had been installed legally pursuant to a valid warrant. A valid warrant would take care of any Fourth Amendment search and seizure issues, but does not set aside the right to counsel that applies after the commencement of an adversarial proceeding. The Sixth Amendment scope has been widened. In March 2016, the headlines of several legal blogs read, "Supreme Court hands down big Sixth Amendment right to counsel win." The case the headline referred to was Luis v. U.S., where the court held that the government cannot seize a person's lawfully held assets that deny him an opportunity to hire an attorney in a pending criminal case against him, even if there were legal grounds to seize those assets. If the government were able to prevent a suspect access to funds to hire an attorney, the Sixth Amendment right to counsel would be meaningless. This case, like the others before it, demonstrates that the Sixth Amendment is broad and important as our criminal justice system seeks to give a person every opportunity possible to enjoy the assistance of counsel.
In the United States Constitution's Fourth Amendment, we're introduced to the concept of probable cause, as that amendment states that no warrants shall issue but upon probable cause. But what exactly does that mean? Unfortunately, the Constitution doesn't define it, and for much of our nation's history, judges, law enforcement, and lawyers have struggled to interpret the idea. In this presentation, we'll look into the development of probable cause, its purpose, and what law enforcement needs to do to establish probable cause for an arrest or search warrant. The Fourth Amendment guarantees the right to be free from unreasonable searches and seizures by the government. Also, before a search warrant can be issued, the government must demonstrate probable cause to believe a crime was committed and that the proposed search area contains the fruits of illegal activity. A probable cause determination balances the right to liberty with the government's interest in preventing and investigating crime. It gives law enforcement flexibility in enforcing the law and protects people from rash and unreasonable interferences with privacy and unfounded charges of crime. Mere suspicion on the part of the police is insufficient. Law enforcement can establish probable cause through live sworn testimony or by a detailed affidavit describing why a warrant is necessary. In 1925, the United States Supreme Court decided Carroll versus United States and provided the contours of probable cause. In that case, the defendants were convicted of violating the National Prohibition Act after police searched their vehicle and discovered that they were transporting 68 quarts of whiskey and gin. In determining that the search was supported by probable cause, the court wrote, quote, "Good faith is not enough to constitute probable cause. That faith must be grounded on facts within the knowledge of the law enforcement agent, which in the judgment of the court would make his faith reasonable." The court further expounded on Carroll's definition of probable cause in Brinegar versus United States, another case that dealt with illegal transportation of liquor. In finding that the police had probable cause to arrest the defendant, who had a reputation for hauling liquor, after they noticed that the vehicle was heavily loaded, the court reasoned, quote, "In dealing with probable cause, we deal with probabilities. These are not technical. These are factual and practical considerations of everyday life, on which reasonable and prudent men, not legal technicians, act." Thus, probable cause exists where the facts and circumstances within the officer's knowledge are sufficient to allow a reasonable person to reasonably believe that an offense has been or is being committed. The probable cause standard cannot be quantified into exact percentages because it deals with probabilities and depends on circumstances. The court has even stopped state courts from adding more precise quantifications of probable cause. Many search warrants are based on information provided by confidential informants. One study finding that between 80 and 92% of search warrant applications were based on anonymous tips. Courts analyzed the totality of the circumstances to determine whether a tip is sufficient to establish probable cause. In Illinois versus Gates, the Bloomingdale, Illinois Police Department received an anonymous letter that a local couple had been selling illegal drugs and that had over $100,000 worth of drugs in their basement. The letter also described the couple's travels to Florida to procure illegal drugs and sell them in Chicago. A search warrant for their residence and automobile was then obtained from an Illinois judge based on the Bloomingdale police officer's affidavit setting forth the information in the anonymous letter. The Illinois State Supreme Court concluded that the anonymous tip could not justify probable cause because the letter lacked important details and police weren't able to independently corroborate the letter's details. The Supreme Court, however, disagreed, holding that the magistrate who issued the warrant had a substantial basis to conclude that probable cause existed. Justice Rehnquist wrote for the court that analyzing probable cause under the totality of the circumstances is not rigid, but is fluid and flexible. Probable cause may be established even if a tip appears to be deficient. Anonymous accusations of illegal behavior may justify a search or seizure if police could corroborate some, even if not all, aspects of the anonymous informant's predictions of the suspect's illegal behavior. It appears that establishing probable cause based on the totality of the circumstances favors law enforcement because it's so malleable. Police have a great deal of leeway to demonstrate probable cause because police have so many ways to show that the circumstances demonstrate probable cause. Still, police may not use an anonymous tip alone to demonstrate probable cause, because an anonymous tip alone seldom demonstrates the informant's basis of knowledge or an appropriate level of verification. Accordingly, police must take some time to corroborate an anonymous tip for it to lead to probable cause. Requiring probable cause for a search or arrest warrant has two aims. First, it protects people from unreasonable searches and seizures. And second, it promotes police transparency and accountability, as law enforcement officials must explain to a magistrate why they want to search or arrest someone. Probable cause is not a legal concept frozen in time, as it has proven to be flexible and has been recast throughout our history to ensure that its aims are achieved.
Oh.
All right. Any questions on that?
No, I subscribed to Law Shelf so I could watch those myself and ask questions and all that stuff.
Awesome.
Oh.
Alrighty. Well, have a good few weeks, and I'll see you in January.
Yes, you too. You have a very beautiful Merry Christmas.
Thank you. You as well.
Yeah, and hopefully, a new week, a new life, and then a new year in a new life, I'm hoping everything goes very well. And, yeah, I hope this Rome trip is beautiful and safe, with all the stuff that's going on, because who knows what can happen. I looked at the State Department travel advisory, and due to all the heightened terrorist activity, everybody has an added level of what would you call that? Safety precautions.
Yeah.
And so, yep, my flight leaves at 4:25 p.m. on Wednesday. I show up in Rome on noon. Already got my hotel booked, and go from there. So,
Awesome. Well, have a great time and stay safe, and we'll talk again in a few weeks.
Yes, Merry Christmas and Happy New Year.
Merry Christmas and Happy New Year. Can't believe we're there already.
Right? Just out of curiosity, would you happen to know how many times I've been found incompetent to proceed? I wrote an email to the lawyer and to the public defender asking, or not the public defender and Jason Lawrence, the evaluator. No. And so the evaluator said he wasn't sure. I would have to get in contact with the public defender, but he also stated that they're very busy and they might not be able to get back to me.
Yeah. I only have your last two evals, and I know
they were incompetent to proceed.
Yeah, but I think you were going through this a little bit before.
Yes, ma'am.
So I don't know the total. So far, I see 2.
Alrighty. Well, thank you.
Okay.
And
yeah.
Be safe for Christmas and New Year's.
Thank you. You as well.
Awesome.
Bye.
Peace. Look. Look. Oh my goodness. Oh, I'm so tired. I got no sleep last night. Holy fuck. Oh. Thank you for letting me know. If you could email me once you're back in Colorado, please. Yes, ma'am. Will do. Thank you. Alrighty, everybody in YouTube land. Like I said, I got basically no sleep last night. I am so tired. Yeah. So yep. Everybody in YouTube land, stay warm. If you need to stay warm, stay cool. If you need to stay cool, stay healthy, stay safe, stay sober for truth and sobriety. I need to get some more sleep. It's Monday. I gotta pack my bag, practice pack all my stuff, do some laundry, and go from there. Oh my god, I gotta get some more sleep. Yeah, everybody in YouTube land, stay warm. Stay warm if you need to stay warm. Stay cool if you need to stay cool. Stay healthy, stay safe, stay sober for truth and sobriety. Because I am. Peace. Love you. And broadcast quick. And broadcast quick.